about these terms before, at least some of the terms: anti-money laundering, money laundering, laundering, terrorism, financing, countering terrorism, so on and so forth. Anyone who has heard the term anti-money laundering or money laundering, what do you mean by money laundering? Anyone has any idea? There are people who are already working in banks, if I can recall correctly. And can anyone tell me what do you mean by money laundering? Or what does it bring to your mind when you hear the term money laundering? If one can unmute and talk, because today most probably would be the last lecture that I'll be conducting. If you all could unmute and tell me or share with the class what we mean by money laundering. Yes. Anyone?
Yes, sir. Getting the black money into the white money. It's
More or less the crux of that. Yes. Thank you for that. In simple sense, that is what it is. We will see going forward how and what the periphery and the boundaries that we'll be talking about, and how crucial or how serious this issue is all about. You will understand when we go through. So these are the areas that we'll be going through today. The cycle of laundering. A typical money laundering scheme, you would see there are three stages of money laundering: placement, layering, and integration. These stages commence consequently. So we will see what this each stage, the process, and what happens, what goes through each stage in terms of a typical money laundering scheme, right? Under the placement, right, the collection of dirty money. What they do is, if you all need to launder, the simple English meaning of the term laundering, we use laundering. What do we use laundering for? For an example, clothes, cleaning the dirty clothes. For us to clean the dirty clothes, we put that into the washing machine, for an example. Washing machine is the mechanism as to how we are going to clean it. So you will place it and you integrate it with certain things, and there are certain other areas where the financial laundering has more than the typical or literal laundering, that is layering and then integration. So you place it, the process of laundering goes through stage number 2 and 3. You place the washing machine is the financial system in relation to money laundering, and the clothes, right? You put the dirty clothes into the washing machine. Similarly, in money laundering, you put the dirty money into the financial system. So what do you do? How do you do that? Each day in, day out, without our knowledge, we may also become accessory to certain money laundering, assistance giving to launder money in our day-to-day jobs when we are in the financial sector, providing the services for the financial sector or otherwise. Once the money is placed, maybe in the financial sector by way of deposits to, getting down any services from the banks, etc., it's very easy to find where the money came from. So what do they do in order to launder the money, to take it out as clean cash? They try to disguise it. How do they do that? They create so many layers where you can't track back the source of the money. So putting that into so many layers, like for an example, you wire transfer to somebody else, and or else you invest on certain other property, so on and so forth. Transfer between various banks in the country and outside the country, both, right? So it becomes very difficult for you all to, for the financial institution to trace back the origin of the funds. Now, afterwards, there is no use if you cannot use the money. So, what do? They want to get it out of the system again. So, by way of integrating it to the financial system once again, by purchasing of luxury assets, financial investments, etc., they will try to integrate. So, this is in the simple sense, the straightforward sense of money laundering scheme in order for in academic value, but the actual process is very much more complex, right? We will go through it and we'll discuss certain examples as well, right? Now, why do they use the financial sector? Because it's easier for them to, there are many products in various terms and various nature for them to use the laundering process, to be used in the laundering process, especially in the second and the third stage, that is layering and integration, right? So placement of different sorts. For example, by way of buying or investing on antiques, car dealerships, right? Property, real estate, gem jewelry merchants, gold and precious metals. What is the most common thing amongst what I just mentioned to you? Uh, Yeah, now only I saw your answer, Krishni. Correct. Very good. And Lorenzen, yes, correct. So my question now is, what's the common element amongst these categories? Antiques, car dealerships, investing on antiques, car dealerships, and in property, real estate, gem jewelry, gold, and precious metals. What's the common element on that? Anyone? You can type it out also. I need you all to, because this is an area which is interesting uh, as well as important, both. Common element of those three said items. Investing in these areas. Don't think too much. Gold, real estate, yeah, there is one common element of common to all of them. Why would a money launderer wants to go and invest in these type? My question is these types of things rather than going and investing on, let's say, uh, uh, a restaurant. Yeah, you're closer. I'm getting so many answers, but uh, it's not really that you don't have to explain how you got the money. It's much more than that. Why this and not let's say opening what do you call fast food outlet, or investing in such certain thing. You all know the answer. I'll just spit it out. All these are high value. The ticket price is very high in relation to the others. Car dealerships, you can see property, real estate, the ticket price is very high, right? Gem jewelry. That's why you would understand, you would appreciate where, even for an example, for all these credit card frauds and all, you will give a certain weightage if there are, multiple transactions or something done at a jewelry store. Why the ticket price is high? The moment one would do is, if he gets ill-gotten money, or else if he has stolen a credit card or something, he won't go and spend it on food and everything, right? What he will do is, try to make, use as much as money as possible. How do they do that? They would go to all these high value places where the ticket price is high. So jewelry is one of them. They would buy gem jewelry, all this, whatever, which is possible to be done in a very small span of time, right? So similarly, uh, this is the area, because high value, because when you're laundering money, you launder in high values. Otherwise, it's sometimes it's not profitable, or for them they wouldn't appreciate the risk, so they would go for all these high value areas like this. Then we also need to understand the legal and the policy framework in financial, what do you call, money laundering and terrorist financing. There is a governing body called the Financial Action Task Force, which is not new. Established in the year 1989, it's quite a long time ago. And the purpose is to development and promotion of policies both at national and international levels to combat money laundering and terrorist financing. Although even in Sri Lanka, this whole concept of money laundering and terrorist financing is not new, you can say now, because it's about the legislation supporting this is about 15 years now, right? Almost 15 years. Now, FATF, right? Financial Action Task Force, they initially made 40 recommendations on money laundering with regard to the legal system of a particular country that they have adopted or they should adopt with regard to money laundering and terrorist financing, measures to be taken by the reporting institutions. When you uh, state by reporting institutions, we'll see what they are, including banks to finance companies, etc., who deal with real estate agents, real estate companies, etc. Then institutional framework, right? What needs to be adopted, then in the international cooperation. And these 40 recommendations were added with further 9 recommendations on the same, and also known as 40 plus 9 recommendations, we will see, right? So a country's overall AML and CFT, anti-money laundering and countering of financing of terrorism, compliance is evaluated on these two aspects, whether on the technical compliance of the particular country after evaluating against the FATF recommendations and effectiveness of those evaluated outcomes. Now, a little bit of financial action task force, they require or expect a high level political commitment from the country. The country will implement the legal, regulatory, and operational reforms required by the action plan of that particular country in executing these recommendations. Sri Lanka falls within the Asia Pacific Regional Review Group, right? One of the 4 regional review groups that carry out this review. Now, Sri Lanka was in the high risk sector, which they name as the grey list for all this time. But in last year, they removed Sri Lanka from the high risk sector because of the commitment Sri Lanka has displayed and due to the legal structure, infrastructure, and the framework, and also the response of the banking and non-banking sector. For all this time, there was an issue more or less with regard to the the response and the compliance and the reporting requirements of the Financial Action Task Force was not very seriously done, or rather was the allegation by the non-banking sector, because there are certain other institutions which has a responsibility under this money laundering reporting, like the real estate companies, to the notaries, to all those people, the jewelers and people who deal with high value uh, items, right? And now the Sri Lanka is no more in the grey list. So these are a little bit. I will share this slides presentation also with you. A little bit of information for your exam and knowledge behind money laundering. A lot of information is available in the central bank website and also on the FATF website on the international framework of money laundering. And now I'm going to go directly on the anti-money laundering and countering of financing of terrorism laws of Sri Lanka, which is quite important insofar as your exam goes, right? We will see what they are, and I will indicate as to the level of uh, what do you call studying that you need to have with regard to these laws. Now, these are the three pillars of laws of Sri Lanka with regard to these areas. First one is the Convention on the Suppression of Terrorist Financing Act number 25 of 2005. Then PMLA and FTRA, we name them shortly. First one being the Prevention of Money Laundering Act, again number 5 of 2006. Financial Transaction Reporting Act number 6 of 2006. The Convention on the Suppression of Terrorism Financing was passed by the Parliament in the 2005, and the other two acts, the PMLA and the FTRA, was sequentially passed by the Parliament on the very next year. That act itself is closer to 14 to 15 years now. Right, we'll first see the Convention on the Suppression of the Terrorism Financing Act number 25 of 2005. Now, before this, I want to ask, so can you share this notes with, yeah, I will share this notes. You don't have to explain how you got the, okay, fine. I have a question for you all. Is money laundering and terrorism is money laundering and terrorist financing the same or not? I want your answers for that. What do you all think? I want your answer. Money laundering and terrorist financing. Okay, I got one answer, not same but interconnected. What else? Not exactly the same. Okay, go ahead. What else? I need all of you all again. I'm reminding you to participate in this Q&A. It's just for your knowledge. Otherwise, I could just go through this and just finish it off. This is for your own betterment, I'm asking. I started off learning about money laundering, anti-money laundering, terrorist financing back in 2004 with regard to with regard to the legal framework of Sri Lanka. During that time, all these areas were quite novel to Sri Lanka and Sri Lankans. Even in fact, what we did was we were focusing on catering to mainly to the Europe, because at that time, 2004, like you all just heard, you all heard, the legal setup was not there. Right. So if it is not the same, similar, both are based on illegal transaction. Okay, very good. If, okay, now I'm going to help you out, right? Your answers, majority of them are correct, but we need to know why it is important to know is, uh, uh, in law, we need to see everything in black and white. Either yes or no. So I'm going to give you the answer to the first question. These are not the same, right? So these are two different things. So what you all mentioned were correct. But if it is not the same, my second question is, what is the difference? There is one difference. What is the difference between money laundering and terrorist financing? It's only one difference alone. What is that difference? What is the difference of money laundering and terrorist financing? What is that? What is that? This, you should be in a better position now in being in Sri Lanka to know that after the 21st Easter Sunday attack, which happened last year, and with the knowledge that you have gathered up to now from and out of that, so what's the difference between money laundering and terrorist financing? One difference only. Any guesses? Any guesses? No guesses. Keep in mind clearly, for money laundering, the source is always ill-gotten money. It's always ill-gotten money, right? Black money. For money laundering, there's always black money in use, but that is not illegal source. No. So this is the difference, right? I'm getting answer. For money laundering, there should be black money, right? Illegal sources. But that is not the case for terrorist financing. It doesn't mean terrorist financing doesn't mean receiving money through terrorist organization. Terrorist financing means financing the terrorist organizations, giving them the money. So giving them the money, what do you give the terrorist money for? To what do you call? To throw parties or anything? No, I don't think. It's a different kind of a party for them. Uh, for terrorist financing, yes, source of funds. The source of funds could be absolutely crystal clear legal money. It could be a loan by a financial institution drawn down. It could be the salary of a monthly salary of a person. It need not be black money for terrorist financing. Understand? That's the difference, the main difference between these two. Keep that in mind. So, what is terrorism financing? Involvement with any person, look at this, connected to or acts linked to terrorism and terrorist financing. So, that's a very vast area. Involvement with any person connected to or acts linked to terrorism and terrorist financing. Then funding for terrorist activities by legitimate or illegitimate sources. Look at that. This is what I was explaining to you. legitimate or illegitimate, right? Even it could be through legitimate sources, right? This is section 3 of our act on the Convention on Suppression of Terrorism Financing, right? As amended in 2011, as to what they mean by terrorist financing. Any person who, by any means, directly or indirectly, unlawfully and willfully, provides, right, or collects funds or property with the intention that such funds or property should be used, or in the knowledge of that they are to be used, or having reason to believe that they are likely to be used in full or in part in order to commit an act which constitutes an offense within the scope or within the definition of any of the treaties specified. So there are certain treaties specified. We will see what the treaties are. Treaties are international conventions by countries where they have adopted to adhere to such conventions, right? Or any other act intended to cause death or serious bodily injury to civilians or to any other person not taking an active part in the hostilities in a situation of armed conflict or otherwise. And the purpose of such act by its nature or context is to intimidate a population or to compel a government or an international organization to do or to abstain from doing any act or any terrorist act. Now, why I took the trouble in reading all this is to ensure that you understand the gravity of this, and I want you all to relate this to the unfortunate thing happened to our country last year, right? Any other act intended to cause death or serious bodily injury to civilians or to any other person not taking an active part in the hostilities. I don't know those who are connected today with me for this lecture, the background, but then again, I know you also might have certain experiences of your friends, family, extended, or otherwise, who became victims to this, friends, right? How serious this thing we are talking about, right? And the fact that now there are investigations going on still on the wire transfers, the funding that were made in order to put this across, because without money they couldn't have made this a success. They did that successfully. So who is responsible is one thing. Who is liable is another thing. Who comes within the purview of committing a crime is provided under this section 3.1. Any person who by any means, any way, directly or indirectly. So if you don't need to say, no, I didn't give money to him. Someone can't say, no, I didn't give money to him. He may have transferred the money with the knowledge that it will be given to him eventually. Unlawfully and willfully provides or collect the funds or property with the intention that such property or the funds should be used, or in the knowledge that they are to be used. Not only that, even if he didn't have the knowledge, this imputes the knowledge. They say with the knowledge to be used or having reason to believe that they are likely to be used, plus in full or part time. Right? So it's quite serious. Terrorist financing. So these are the treaties which I just mentioned under the Schedule 1 in the convention, right? The Convention for the Suppression of Unlawful Seizure of Aircraft, made in Hague. Unlawful acts against the safety of civil aviation in Montreal. Convention on the Prevention of Punishment of Crimes against Internationally Protected Persons, including diplomatic agents, in 73. Convention against the Taking of Hostages in 79. Convention on Physical Protection of Nuclear Material in Vienna Then suppression of unlawful acts of violence at airports serving international civil aviation, supplementary to the Montreal Convention, which we spoke earlier. Then Convention for Suppression of Unlawful Acts Against the Safety of Maritime Navigation. Then Convention and suppression for the suppression of unlawful acts against the safety of fixed platforms located on the continental shelf. It was made in Rome. Again, suppression of terrorist bombings. Right. So these are the conventions that is covered under our terrorism financing convention of financing of terrorism. See, in financing of terrorism, because of that difference I told you, there is no need to show that the funds or property provided or collected were actually used in the offense. Right? You really don't have to. Destination of the funds is enough. Whether it was used or not is not a question of fact, neither a question of law, in order to be culpable or be liable under this act. You can't say, no, I sent money to this guy to blow up something, but he blew up something else. So I'm not liable under this. No. Financing of terrorism, whether they do the act, terrorist act or not, that is liable. So, involvement with any person connected to or acts linked to terrorism and terrorist financing, funding of terrorist activities by legitimate or illegitimate, right? This is the terrorist financing in a nutshell. Now, who is a terrorist? Terrorist means any person. Terrorist means any person. You look at the term, the English term, terrorist, person who insinuates terror, Bayankara, directly or indirectly, and willfully commits or attempts to commit a terrorist act, participates as an accomplice in committing a terrorist act, organizes, directs or aids or abets උදව් කිරීම සහ හවුල්වීම උදව් කිරීම සහ උල්පන්දන් දීම, the commission of a terrorist act, right? සහයෝගය දීම, right? Abets is a terrorist act. Or, right? It's not and, it's or. So it's maybe one of those, or contributes to the commission of a terrorist act by a group of persons acting with a common purpose, where the contribution is made intentionally and with the aim of furthering the terrorist act, or with the knowledge of the intention of the group to commit a terrorist act. Now, is that contributes to the commission of a terrorist act by a group of persons acting with a common purpose, where the contribution is made intentionally and with the aim of furthering the terrorist act, or with the knowledge of the intention of the group to commit the terrorist act. So this is quite important, even for your knowledge as well, for the exam also, as to what do you mean by a terrorist act. Give me a moment. Terrorist. What do you mean by a terrorist act? An act which constitutes an offense within those specified in the treaties. Any other act intended to cause death or serious bodily injury to civilians or any other person, or even through the use or threat of action which is designed to influence the government. So I'm not going to go through all this. I will share these slides with you with the institution intern. They will share this with you. Go through this, be savvy, be very familiar with these areas, and try to, an easier way for you to remember is, try to relate this with the recent incident which Sri Lanka had to go through, right? It's pathetic, right? And we need to understand whether we are helping that or we need to counter that. Knowingly or unknowingly, are we assisting certain things? Sometimes we might being in a bank, it's not only illegal, it's our country we are talking about, and also internationally it's about the humans that we are talking about in a wider scale. So it's pretty important. So what's the framework now? In the event if there is a suspicion of funds being used to terrorism and terrorist financing, the ASP, the Assistant Superintendent of the Police of the area, has the right to give an order freezing the account. I'm talking about freezing the funds in the account for 7 days, right, in the first instance. However, he has to, because you need speedy action, because the time, the funds, they move very fast, quite fast. So so he has the power under the Terrorism Financing Act to give a freezing order uh, on the account for 7 days. Then he has to go to the High Court to get that time extended 3 months at a time and for an aggregate of 2 years. Afterwards, he has to publish that in all three languages to be published and suppose claim for legitimate business to continue. Right? And so then the action against the perpetrators would be continued in court under the terrorism financing. So it's a big deal. It's quite large. It's a huge concern and issue. Uh, therefore, uh, keep in mind, because sometimes what the risk of this is, sometimes the bank gets the notice from the not anyone, right? It should be the Assistant Superintendent of Police under the terms of the Terrorism Act and not under anything else. Uh, and if the bank gets the officer gets delayed to take action on that. And for an example, they got the what you call notice or the order, freezing order, let's say at 3 o'clock. But then when they actually froze the account, the banking staff at, let's say, 3:30 or 4 o'clock. During that window, if the funds were transferred, what would be the consequences? Consequences in addition to the main or the most the most what do you call scene consequence of terrorist act, consequences to the banking officer, that he or she would be tried under the terrorism act for aiding and abetting, right? Because of that, so you be very vigilant and assertive in these areas, because it's very important that you protect the country and also protect yourself, right? Any questions on terrorist financing? If you have, you can ask now. Any questions? Right, no. We will go to the next one, which is the Prevention of Money Laundering Act, number 5 of 2006. It was amended by Act number 40 of 2011, right? On anti-money laundering, Prevention of Money Laundering Act, or PMLA. So crimes are defined under the Unlawful Act and as a predicate offense. What do you mean by a predicate offense? We will see. Right, then getting money through a crime and using the proceeds of the crime. Basically, these are the areas which the PMLA would be governed. Look at them again. On what do you mean by crimes? The Unlawful Act. predicate offense, right? Then getting the money through a crime and using the proceeds of the crime. Right. Jurisdiction. Now, this is the applicability of the act that we are talking about, right? A person commits an offense under the act whilst being a resident in Sri Lanka. So, any person who is in the soil of Sri Lanka uh, will be coming under the provisions of this act. Any institution used to commit the offense who carries on business in Sri Lanka comes under this act. Right. Um, then, incorporated or registered as a branch of a bank, incorporated or registered outside Sri Lanka. Right. I will pull the. Give me a moment. I'll pull the actual act. This is the Money Laundering Act, number 5 of 2006. You would see under section 2, it says to whom this act is applicable. So, any person who commits an offense under the resident may be under the resident visa, right? Or an institution which is used for the commission of the offense under the provisions of this act and which constitutes an offense under this act which is committed in Sri Lanka, right? These are the areas where these are the applicabilities of this act. Then it goes to the offense of money laundering. Look at this. Any person who engages directly or indirectly in any transaction in relation to any property which is derived or realized directly, indirectly from any unlawful activity or from the proceeds of any unlawful activity. When you really clearly read this once again, you will see that even a bank officer may be, coming within the provisions of this definition. Right? Read that once again. Right? So, engages directly or indirectly. You might not engage in money laundering, but then again, you might be assisting without on in money laundering if you haven't done your job properly. We'll see about these jobs are actually right, right. Directly or indirectly engages in any transaction in relation to any property derived from unlawful activity or proceeds from unlawful activity. So unlawful activity, not necessarily. If it's a bank robbery or something, yes, unlawful activity. If it's a robbery of any, I think unlawful activity. But then again, then that money is being brought to you. Those are the proceeds. So if you are dealing engages in those transactions on the proceeds of money laundering of unlawful activity also comes into the picture. Receives, possesses, conceals into out of or invests in Sri Lanka. Any property derived or realized from any unlawful, they also come under the offense of money laundering. Knowing or having reason to believe that such property is derived. So, not knowing, you have the knowledge that this property is ill-gotten property. Then, or you may not know, but you have a reason to believe that this property is ill-gotten property. Such property is derived or realized directly or indirectly from any unlawful activity or from the proceeds of any unlawful activity. That person will be guilty of the offense of money laundering. This is far more or very serious. If anyone is caught of laundering money, I'm telling you, practically that's the end of that person's literal normal life. Because the state is very keen, very serious about not leaving room open for these types of activities, right? So, offense of money laundering. Any transaction What could be the unlawful activities? Sri Lanka follows a list-based and a threshold demarcated offences approach as opposed to all offences, right? That is specific offences as well as an omnibus clause. Omnibus clause is where you provide at the end where for offences where the punishment is over 7 years if somebody has committed, right, that offense or money realized out of that offense also comes within the purview of this. Now you would see for manufacture, trafficking, import, export and possession of dangerous drugs under the dangerous drugs ordinance, solicitation and no acceptance and no giving bribes or inducements and no involvement in acts of corruption, offences against children, activities related to unauthorized possession or use of guns, firearms, offensive weapons, explosives, exchange control violation, as you know, these conduct of prohibited schemes as pyramid schemes. These are the main offences. For these main offences, the predicate offense is the money laundering. Is money laundering, right? Laundering of money. Predicate offense means an ancillary offense to the main offense. Main offense is trafficking drugs. Ancillary to that main offense is money laundering, laundering money from the proceeds of the crime. Keep that in mind. Violations of customs ordinance, violation of excise ordinance, National Environment Act, Payment Devices Fraud Act, all these are, this is the omnibus. An offense under any other law, punishable by death or with imprisonment for a term of 5 years or more, and includes the penal code offenses of criminal breach of trust, criminal misappropriation and cheating, right? These comes within the purview of Money Laundering Act. So, you can't give an exhaustive list of offences. So, all the offences which comes within this purview, the last one, which is provided in black color, comes proceeds of it or engages in any such offences comes within the purview of money laundering. Then, if a commence is committed by a body of persons, body corporate, for an example, private limited company, every director or other officer, if it is committed by a firm, every partner, if it's an unincorporated body other than a firm, members and the persons in management and control, persons in management and control. The only defense available for a person to absolve from liability is to show that I did not have knowledge of such an action, plus I exercise due diligence on that. So section 18 of the Money Laundering, Prevention of Money Laundering Act says this. We see offences by body of persons. Where an offense under this act is committed by a body of persons, then if that body of person is, if he proves that the offense was committed without his knowledge or that he exercised all due diligence to prevent the commission of the offense, not majority of the due diligence, but all the due diligence, right? So these sections that I have mentioned are imperative or important. Suspect needs to show proof. Now the normal principles of law is that you are innocent until proven guilty, right? You are innocent until proven guilty. the person who accuses you of certain things needs to prove. So, a person who accuses the other person, whoever, always who complains, is where the burden of proof lies. So, he has to prove his case. Now, the importance of money laundering act is under this, quite contrary to the acceptable principles. Under money laundering, there is no presumption of innocence. It's the other way around. You have to prove that you are innocent if you are being charged. So the burden is on the accused or the person who has been accused of laundering money to show or get himself out of that situation. That is the same case for customs ordinance and matters coming under the customs ordinance and Indian revenue tax matters, right? So, duty to disclose to FIU, director, officer, or servant of the institution, failure to do so, it is punishable by the High Court, right? And the prison term is no joke, right? It's no joke. So, no person shall falsify, conceal, destroy, or otherwise dispose of, or cause or permit the falsification, concealment, destruction, or disposal of any document or material or thing which is so likely to be relevant to the execution of any order made in accordance with the provisions of the Act. Derives the fact that an investigation into the offence of money laundering or an offence under the law of any foreign state corresponding to the offence of money laundering is being or is about to be made or divulge any other information to any other person whereby such investigation is likely to be prejudiced. This is called the tipping off. Where majority of the the bank staff will be exposed to. So when there is a ongoing investigation, internal or otherwise, with regard to an account on money laundering, on suspicion of money laundering, and if the customer asks what's happening, maybe you have held on to a fund transfer. You can't mention, you can't inform the customer your account is your account is under the investigation for possible money laundering. You do that, then you will be committing an offense under the provisions of this act and you will be severely dealt with. Right? That is called tipping off. Again, same process for freezing and forfeiture of assets by Assistant Superintendent of Police. Reasonable grounds to believe any person is involved in any activity relating to the offense. Right? Freeze for 7 days and thereafter you can get it extended by an order of the High Court, right? If you do not, the bank do not comply with a freezing order of such, it is punishable under the law, right? So, any questions on money laundering? Any questions? Keep in mind that this is a predicate offense. What is a predicate offense? An offense which is ancillary to the main offense. Right? So they have given under the interpretation, what do you mean by designated non-finance businesses? So you can see under section 35, please go through this act, right? Safe custody services, underwriting, trustee administration, gambling, casinos, lottery conducting, right? Real estate, dealers in precious metals, semi-precious stones, etc. And lawyers, notaries, other independent legal professionals, and accountants when they prepare for carry out transactions for their clients in relation to any of the following activities: buying and selling of real estate, managing of client money, management of bank savings or securities accounts, organization of contributions for the creation, operation, and management of companies. All these are coming under designated non-finance businesses. It is on this under this category where Sri Lanka was under the grey list because this category was not 100% compliant. I would put it that way, 100% compliant with the requirements of FATF. Right. So property means any currency, which includes any asset, any of any kind, of corporeal or incorporeal, movable or immovable, tangible or intangible. What are intangible assets? What are tangible assets? What examples? What are what are tangible assets? Question to you all. Examples. Examples of tangible assets. Yes. Examples of tangible assets. No idea. What is the meaning of the term tangible? Right? No idea. Ooh. What's that? What is PPE? Oh, all right. Okay, physically existing. Plant, equipment, good. Assets that can be touched. Yes. Thank you. So, intangible assets. Are there any intangible assets? If so, what? Intangible assets. Good. Very good. Very good. So the brand names, intellectual property. Those are intangible assets. Right? Good. So this is what we discussed. What do they mean by unlawful activity? Means any act which constitutes an act which constitutes an offense under these acts, or an offense under any other law for the time being in force, which is punishable by death or with imprisonment, or punishable by death or with imprisonment of for a term of 7 years or more, not 5 years, 7 years more, 7 years or more. So, any questions on that before we proceed? Yeah, very good. Right. Any questions? Any questions on that? No? All right. Then we will go to Financial Transactions Reporting Act. also known as FTRA, right? Scope and role of FIU. FIU, Mulya Buddhi Ekakaya, Financial Intelligence Unit. They look at or investigate offenses with related to money laundering and terrorist financing. So it is by FTRA that they have created this institution or section called, or have given the power to this part of the central bank as this unit of the central bank as FIU, Financial Intelligence Unit, right? The provisions of this act, FTR, is applicable to finance businesses. We will see sections 35 interpretation to what is meant by finance businesses within 35. Right, this is section 35. Rather 33, right? What do you mean by finance businesses? Includes any one of the following business or activities: banking under the Banking Act, finance business under the Finance Companies Act, Finance Business Act now, lending including consumer credit, financial leasing, transfer of money or value, money and currency, issuing and managing means of payment, credit cards, traveler's checks, not anymore, issuing financial guarantees, trading of its own account or for the account of customers, checks, bills, certificates of deposits, participating in securities issues, and any other which is prescribed by the minister, right? Designated non-finance businesses, not different to that of the PMLA. Lawyers, accountants, casinos, real estate dealers, dealers in precious metals, etc. These people, why these categories of people, the professionals, they get what do you call confidential data or confidential information with regard to their clients. So by way of which, that's why the state has given a higher priority than that of that confidential matters, because under Money Laundering Act, right, PMLA, it is not an offense to report to the FIU or to the Financial Intelligence Unit, or make a report on that, or freeze the accounts. It is not a violation of Section 77 duty of secrecy, right? Duty of secrecy is is limited at that point, right? So even that, the same principle applies to, now there is a duty of confidentiality towards the client's data by the lawyers, accountants, etc. So that is applicable in this instance as well. Now, statutory obligations under the FTRA. Now, this was established in the year 2006 under the FTRA. There is a mandatory reporting of cash transactions and EFT, so electronic fund transfer. It was reviewed, and for all transactions which is over 1 million needs to be reported, right? Whether they are suspicious or not is immaterial. That's not in the issues. It needs to be reported nevertheless. Then that's section 6 of the act says that. Right, an institution shall report to the financial FIU any transaction of any amount in cash exceeding such sum as shall be prescribed by the minister, 1 million. Any electronic fund transfer, the request of a customer exceeding such sum as shall be prescribed by regulation. Right. So keep these things in mind. Section 7. What is a STR? or suspicious transaction report, where an institution has reasonable grounds to suspect that any transaction or attempted transaction may be related to the commission of any unlawful activity or any other criminal offense. Now, see here, it's important to understand that they have imputed the thought of a reasonable man. If I am a reasonable man, I need to act reasonably with regard to certain situations that I come across in a day-to-day life. My question to you, let's say I'm giving you a certain scenarios. You tell me whether uh, is it normal to think this particular scenario which I'm giving according to a reasonable man. A person who is in his age of, let's say, 25, his or her, getting monthly credits of rupees 65,000 to his account. To his account. This normal for a reasonable person. Question. What do you all think? What do you all think? Bankers? Don't worry, you can go ahead and answer. You will not be judged or tested or prejudiced. This is important for your professional life also. Can be. So when you're answering, don't give just, yeah, good. So like that, yes, it can be his salary. Like that, give the explanation for your answer also, right? Your salary. What else? So same age. Yes, depends on his occupation. Yeah, same age, getting 1,000. Same age, 300,000 cash deposits every week. Is it normal? Or not normal for a reasonable, normal person? Okay, some says it's not normal. What else? Yeah, not normal depending on his job. See, the idea here is not to prove or to argue, otherwise saying that no, he can be. Why don't you think? No, there will be people. No, it's not about that. Keep this in mind. It's not about the fact that there can't be any people who would be getting 300,000 cash every week. There could be people. It's not what we talk about. That's not the issue here. What we have to talk about and think here in the line now, that's not normal. That doesn't mean this guy is a crook. No, but it's not normal. He may have his legitimate sources, he may have, but that's maybe an exception. But for majority or the normal parlance, it's that it is not normal. So you can't deny that. It's not about arguing this particular case. It's about arguing whether it's normal or not. If it is not normal, you have to investigate more. You have to ask more questions. Customer due diligence is bad. That's why it comes to play there, right? CDD, know your customer, KYC. It's not only enough to know your customer. Now it goes to KYCC, know your customer's customer, right? So these matters comes into play, and the knowledge of a reasonable prudent person is imputed to the head of the person who is investigating. That's the branch officer or the bank officer who is entrusted in doing that. And also the first line of defense, the tellers, the persons who meets with the customer, deals with the customer, he knows the customer better than the back office staff. So he needs to know there might be a situation where the customer gets about a 400 million deposit, right, or 40 million deposit, and the back office might be panicked and all, and say that how on earth he gets the money, we need to report that, he's definitely a terrorist, so on. But the frontline staff may be well aware that he is a person who is with a very what do you call rich family background, and he may have received his uh, what do you call succession, testate or intestate, right? Uh, so inheritance rather. So it's about dealing, having the CDD, customer due diligence, KYC, and also all areas of the bank being interconnected or communicating with each other to understand where the customer is coming from, to understand the customer basically, right? So that's very important. So a person shall not disclose to any other person that a report has been made or information provided to the FIU in terms of provisions of the Act. Suspicion in relation to the transaction has been formed, or any other information from which the person to whom in disclose could reasonably expected to infer that the suspicion has been formed or that report has been made, has so may be made. Now this is the tipping off provision that I mentioned. However, you can disclose that provisions of tipping off will not apply to if you disclose those that type of information to an officer or employee or agent of the person making the report under that act, connected with that performance of that duty, or a lawyer, attorney, or legal advisor for the purpose of obtaining legal advice or representation or supervisory authority in the institution, right? Right. Then we go to STR, the suspicious transaction report. It's a report made by the reporting institution, that may be any bank or all those reporting institutions which I mentioned to you, financial businesses, finance businesses or non-finance businesses, regarding the suspicious or potentially suspicious activity, right? So all reporting institutions to file STRs with FIU, and FIU to establish procedures to ensure that STRs are reported. Right? Now, when you look at the operational analysis of these STRs, there should be a database to trace the existing financial relations. Right? A database for previous suspicions reported. And you should be able to call for further information on STRs. Validate the information from open sources like in the internet. because there should be internet also plays a huge role in identifying and treating whether something is normal or not. All information collected through this is evaluated and final analysis reported is submitted to the STR review committee. This is done by the FIU, right? The FIU will be equipped with all these areas. Right. And it's important that you have all the details at the finance institution to identify the customer. If you can't identify the customer, that's an issue or an offense under the provisions of this act. I'll just go to section 2 and explain. No institution, look at this, shall open, operate or maintain an account where the holder of such account cannot be identified, including any anonymous account or any account identified by number only, or any account which the knowledge of the institution is being operated in a fictitious or false name. Right? In other terms, you can't have numbered accounts as well, like in the Swiss. You have to have the due diligence KYC conducted on the customer, and there should be a person for the account, right? Right. So the previous rule was regarding this Gazette in 2011 on know your customer and due diligence, and it was revised again in 2016 on the customer due diligence, and these rules are applicable to all financial institutions. In other words, all that engage in finance business as defined in the interpretation as in the FTRA, right? So measures under the FTRA to keep in mind, section 4 says, we go to section 4, every institution shall be required to maintain records of transactions and correspondence relating to transactions, and records of all reports furnished to the FIU for a period of 6 years from when? From the date of the transaction, correspondence or furnishing of the report as the case may be. So if it's a transaction, from the date of the transaction, from the correspondence, from the date of the correspondence, from the report, from the date of the report, right? Records of identity obtained in terms of section 2 for the period of 6 years from the date of closure of the account or cessation of business relationship as the case may be, right? So this is important. Then section 5 goes on to read the CDD on risk profiling the customer. An institution shall conduct ongoing due diligence on the business relationship with its customer. Institutions to conduct ongoing due diligence. Ongoing due diligence means knowing or understanding what the customer is going through, what the customer is doing, what are the customer's needs, wants, what the customer lacks, etc. So basically knowing everything about the customer. Conduct ongoing scrutiny of any transaction undertaking. Unlike KYC, CDD is KYC is one time. CDD is a continuing thing. Continuous customer due diligence, right? Ongoing scrutiny of any transaction undertaken throughout the course of the business relationship with the customer to ensure that any transaction is being conducted is consistent with the institution's knowledge of the customer and the risk profile, including, where necessary, the source of funds. Right? So if it's a customer who deals with, if your customer is a, let's say, car detailing shop, and to the account you receive 1 million rupees every day. He has only one shop. So that doesn't tally with the risk profile, doesn't tally with the customer profile. Understand? It's inconsistent. Under section 14, every institution should have or appoint a compliance officer who is responsible for ensuring institutional compliance within the requirement of the Act. You need to have training for that person, updating themselves, typologies, use of technology. This is utmost important. Your compliance officer is statutory required position, which should be appointed within the company to be responsible for all these matters. Right? Right. So statutory powers of FIU under 15, we'll see. Suspension of transactions for a period of 7 days and extension through High Court. So similar to that of ASP, they also have the power to suspend without a court order in the first instance, right? So ex parte action, they can go to High Court ex parte without the presence of the other party. The FIU can either suspend a specific account or suspend all accounts under the given NIC, right? The FIU has that power. And the suspension will be addressed to CEO, MD. These are trivial things. I won't be, going through much on this. Then, if there is a suspension or a freezing order, the bank should not carry out any debit transaction unless specified by FIU. Should continue with credit transactions, right? Understand? After the expiry of 7 days, Section 15.3 allows the FIU to make an ex parte application to the High Court of Colombo to extend that. We just discussed that, right? To extend it. If there is no suspension of transaction, carry out business as usual with the customer. No difference. Any further developments, FIU will be informed. And you should inform the FIU, right? Opening of further accounts, request for closure of accounts. You need to keep FIU informed of that. This is if there is no suspension on transaction only. All right. Tipping off the customer, we discussed about this. For Section 9, should not disclose to any other person that a report has been made to FIU, suspicion has been formed. Further information has been submitted to. So the most popular question that is asked is, can I tell the customer that the account is suspended? Yes, you can, and you have to. Otherwise it's ridiculous. Customer might ask, why am my transaction not going through? You can say I don't. You can't say I don't know. You have to say the account is suspended, but you can't disclose any further than that, right? You can't make or you can't inform him that there are things that are done under Section 9, right? Right. So Section 12 says, no civil, criminal, or disciplinary proceeding lie against any person or institution reporting STRs under the FTRA in good faith or in compliance with regulations made thereunder, right? So you can't try any officer or a clerk or any employee of the bank for reporting or disclosing that, because that's here it's expressly states that it's not contradicting Section 77 banking secrecy requirements, right? So right, for non-compliance, this is not the most crucial thing. It's the not 1 million penalty, but the prison sentences, right? So FIU is linked with all the required, because they need to have an understanding of not only one transaction but of all the transactions and about the customer. So regulatory arms, they are linked with the CSC, Securities, SEC, Insurance Board, Bank Supervision Department, Exchange Control, Department of Supervision of Non-Banking, Public Debt And from law enforcement, police, CID, FCID, TID, SIS, state intelligence, and police narcotics. And with regard to the prosecution, if any required for the high court, like the extension, the attorney general's department, immigration and immigration, because they need to act quickly to impound passports, RMB to get the information, Inland Revenue, Department of Customs, Ministry of Foreign Affairs, Defense Ministry, and of course reporting institutions like the banks, finance companies, insurance, etc. Right? These are some of the high value fines imposed on international banks, not by the local FIU, but by the local, respective local financial intelligence units of the respective countries, right? For allowing, not for engaging, allowing certain rogues or money launderers to launder the money, to use the bank to launder the money. So you would be aiding and abetting. Under that, they will be fined. It's not small amounts, 10 billion pounds, 97.44 million US dollars back in 2017, 586 million is a settlement with the Department of Justice and HSBC, which was subject to one of the most highest scrutiny with regard to anti-money laundering and allegations of certain mobs and terrorists and of Mexico and all channeling their ill-gotten money on drug trafficking through HSBC offices internationally, specifically in South America, right? And the Department of Justice in the US came for a what do you call a deferred prosecution agreement with the HSBC, deferred for a period of X number of years, about 4 years, and there is a fine, but also there is a condition that under the agreement, HSBC had to gear up their compliance on anti-money laundering and also to ensure there is no single event of recurrence in such offense, in such events in the future. So they did a pretty good job, and they have even appointed a monitor on that. Right, and that's how it went. So these are the penalties on this. So that's about money laundering, terrorist financing, and financial transactions reporting. We are ahead of our time. If you all have any questions, not only this, but from anything that we have discussed up to now, you can ask from me now. This is the time. This is the time. No questions. Then we can wind up on this. If there, I will let the institute send this material to the institute to be shared with you all. Hopefully, if there is no other thing, we can wind it off for today. So all the very best.